Good afternoon. My name is Ola Malik, and I'm the president of the CBA Alberta branch. In a very short time, the COVID-19 outbreak has had a profound impact on all of us, on how and where we work and connect with our clients and work colleagues, how we live our lives with our kids and family, and how all of us are helping our clients navigate our courts at a time of adaptation and change. As the voice of the legal profession, the CBA regularly engages with various stakeholders, including the courts, government, the Law Society of Alberta, and various other legal associations. Today is no different. COVID-19 has required all of us to work together to find new ways of practicing our profession and to ensure that our courts remain open and accessible for the work we do for our clients. Our profession is undergoing an immediate crisis, the likes of which we haven't seen in a lifetime. Our members know that their professional lives won't quite look the same when they return to work. Some of you may not have jobs to return to, while others may see your work environments greatly changed. There is, and understandably so, a great deal of apprehension about what the practice of law post-COVID will look like. There's little question that COVID-19 has exposed fundamental structural shortcomings in our system of administration of justice. Addressing this may very well require, as some have argued, a complete reimagining and big systems change. This is a critically important discussion we can't avoid, but we'll need to leave that for another day. Today, our focus is on where things are right now, how all of you and your clients are doing, and how we can engage in further discussions about what's next. I'm therefore deeply appreciative to our Chief Justice, Mary Moreau, and our Associate Chief Justice, Ken Nielsen, for having agreed to join us today in this webcast to CBA members. We're going to have a conversation that will touch on three aspects of change that impact us all. We're going to talk about some of the recent process changes and bring us all up to speed. We're going to share some thoughts on how we deal with the transitional period from COVID to post-COVID, and we'll have a tentative discussion, albeit a short one, about what the future may hold. And before I introduce you to both our Chief Justice and Associate Chief Justice, there's a couple of things to say. Firstly, we're having this conversation within the context of the Premier's remarks yesterday evening, which is that we're likely not going to see any variations of the restrictions, the flow from the public health emergency until the end of May. So we're here for the time being, and we're certainly here for a while. And secondly, when we advertised this webinar, we filled up our maximum capacity in less than 2 hours. And so for those of you who have colleagues or friends who would have wanted to join us today but who can't, I can tell you that we'll post this webinar to our website as soon as possible. And we're also sharing the website to be posted on the Queen's Bench website. And finally, you'll notice in your Zoom screen in front of you that if you click on those three dots at the bottom and you go to the Q&A option, you do have the capacity to type in some questions. Now, there are a number of questions, and I'm not sure if we'll get to all of them, but if we don't, those questions will give us some important information about what we can take back to our stakeholders for further discussion. So first, so now let me thank both you, Chief Justice and Associate Chief Justice. I want to thank both of you, each of you, and your teams, particularly for the incredible work that you've been doing. Chief Justice, I know that you've been extremely busy meeting with any number of stakeholders, including the Law Society, the Minister, government officials. And from our perspective, it's something we really appreciate, meeting with our section executives in various different practice areas. You've done some of those, you'll be continuing to do those with our family law, civil litigation, criminal justice, and surrogate matters, and we're deeply appreciative of the time that you've taken there. And Associate Chief Justice, let me thank you. I know that you've been very busy liaising with representatives from the commercial litigation bar. So to both of you, thank you for taking the time. Chief Justice, let me begin with you. You gave a press conference yesterday. It was the first press conference you've given since your appointment it seems like 10 years ago. I'm wondering if you can tell us what was the point of that press conference and what was your central message?
Well, thanks for this opportunity, Ola, to speak to your members. And I'm sorry we're at a bit of a distance from you. We thought it might be an easier process to have you connected through a courtroom computer, also respecting social distance between the two of us, Ken Nielsen and myself. But I think it's got us at a little further away, but I wanted your members to be reassured that I have the Purell on hand, and we're going to be doing a mid-session handout of, this is our custom, Ken Nielsen and I, whenever we meet, is we pause about halfway through and do a sanitizing. It's a situation where I had, after the first year of being Chief Justice, was one of the emphases of the new administration being communication and outreach. Actually did organize to have a press conference to speak about that first year, what I'd learned, where we were going as a court, and that took place in the fall of 2018. So come around to the fall of 2019, I received the same approach. The media was interested in knowing how the first 2 years had gone, but we were in the middle of budget discussions with the government, and it just wasn't the time to be speaking out about our court because there was uncertainty around the budget. Well, once we got through the budget, the pandemic arose, and it seemed to me that it was an appropriate time in light of the questions that we were receiving very frequently. Lots of emails I'm receiving, and I think that's all good. It's a very engaged bar out there. To find out what was exactly happening on the ground. So with that one request for a media interview, I thought it might be more efficient and effective if we invited all media, accredited media, and that's how I got to the press conference yesterday.
You've been quoted, and you've been quoted as highlighting the importance that technology will play in how we move forward. And I'm wondering if you can just touch on that. My sense was that was one of the key messages that you were wanting to deliver yesterday.
Well, one of the platforms of our administration right from the beginning, and indeed before I became chief, was moving into the technological age effectively with court processes, with e-filing, getting rid of the paper in our courts, increasing efficiency. Obviously, people who are filing paper, our staff members are retrieving paper files for court applications. If that whole function is removed, we can redeploy them to other tasks within the court and really develop some creative responses to how we serve the public. But we were being impeded because we just couldn't quite get that launched in a really concerted way. So what has happened is that as a result of the current crisis, the situation provides no alternative but to move ahead very aggressively in IT innovations for our courts so that we can work remotely. And I'm very happy to say that we've been very supported in that by the ministry. The Justice Minister is personally very engaged in moving this particular agenda forward, that the courts are equipped with the necessary e-filing, case management platforms, and ability to work remotely. So this will be something, as I said yesterday, that will be for the long term. This is one of the consequences of the crisis, and I guess as with many other innovations, there has to be a sense of urgency. And there certainly is one here, and it has moved us essentially into the 21st century.
Thank you. And I should just add that our Associate Chief Justice, John Rook, is also on the video, so thank you, Justice Rook. I understand the Queen's Bench has a pandemic response committee, and I'm wondering if you can tell our members what the purpose and focus of that committee has been and really what its work has been, certainly over the last several weeks.
Well, the committee is what we call an ad hoc committee, obviously not a permanent committee of our court, because as we saw the situation developing internationally, we were very concerned, and the executive board of the court was concerned about moving ahead with a game plan. And so at the end of February, a pandemic response committee was put together consisting of 3 justices from different geographic regions of the province, led by ACJ Nielsen, who is beside me as chair of the Pandemic Response Committee, and members of our executive judicial staff, and the members of our staff who were dealing very closely with our technological initiatives. So essentially, they put together a pandemic response plan, a detailed plan, and one that I invoked on March 15th. That was a Sunday. It's a memorable Sunday. To stage essentially the shutdown of the court to all except emergent and urgent matters. And we fell upon a stage in the plan very quickly where the 13 judicial centers in our province for Queen's Bench were folded into 4 hubs, 4 centers: Edmonton, Calgary, Red Deer, and Lethbridge. And so all the regional centers, and I'm talking about, for example, Edmonton is now dealing with matters from Fort McMurray, Peace River, St. Paul, Hinton, High Level, and Calgary has responsibility for other regional centers. And it allowed us to really consolidate our work. The committee's focus really and its objective is to safeguard the public visiting the courthouse, to safeguard our judicial staff, our judges, while meeting our constitutional responsibility as a court to administer justice. So really, public safety was number 1 on the agenda for the pandemic response team.
So is it only sorry, go ahead.
Well, you go ahead.
Thank you. Is it only the Queen's Bench locations in Edmonton, Calgary, Red Deer, and Lethbridge that are currently open?
Well, we have people working remotely from all regional centers. Our court coordinators are online from their homes in the regional centers, and they're bringing their arraignments, for example, into, if it's the north, into our Edmonton Queen's Bench Appearance Court. So that there is an in-syncing of the different regions, but it's much easier to manage in the 4 hubs because we had to go remote. There was no choice but to do that.
Thank you. Urgent and emergency matters that need to be dealt with in person, are they being heard outside of the 4 hubs?
The matters that are being heard are limited to the 4 hubs. They can be fed in from the regional centers, and we'll speak a little bit later about the process by which applications come before our court now through a virtual filing of a request form for an urgent hearing. But essentially, it's the 4 centers that are in control of the scheduling for all regions of the province.
Okay. Well, why don't we talk about some of the immediate changes that lawyers are seeing at Queen's Bench now? And if you can take us through, Chief Justice, some of the developments. Certainly the amended Master Order number 2 is critical for us to understand. But if you can take us through some of the key highlights in terms of where we are now.
You know, if I can go back just a step, Ola, because I think what members of the bar need to know is that this is not the court kind of inventing a process for itself without some very strong external indicators. And so when we started on our pandemic response plan, at that time, there was a recommendation by the Chief Medical Officer for Health for the province of Alberta to restrict gatherings, for example, of over 50. So immediately that had an impact on our chambers locations. And in Edmonton, we can be running up to a dozen emergency protection order reviews in a given morning, which would mean that there are people congregating in that courtroom to have their matters heard. So we had to essentially break up the crowds when we got that directive, as all institutions did, and businesses, et cetera, that you could not congregate more than 50. Now, then the directive changed to not congregating in numbers more than 15. So that had another very elevated impact on our court, because as you can understand and appreciate, a jury trial, counting 12 jury members, if it's a serious matter that is lengthy, there'll be 14 members, 2 that are standby members of the jury. Then you add a judge, a clerk, you'll add a court reporter to that mix, and you'll have the accused there, you'll have witnesses, and now you've got a group well over 15. So a lot of our measures were dictated by what those external factors are. And so, you know, as we get into a discussion later on about how we're going to open up the processes of the court, when we're talking about the physical plant of our courthouses, I think I can say fairly to you that we're going to be in lockstep with the directives of the Chief Medical Officer and the province in terms of the announcements that we're all getting daily from the Premier, from Premier Kenney, and from the Chief Medical Officer. So I just wanted to give you a little background there on that.
No, I appreciate that. Are you, Chief Justice, hearing any feedback from court staff? So the sheriffs, the counter staff, the clerks, in terms of what their interactions with lawyers are looking like? Are there any ideas or suggestions that we can think about in terms of how we interact with those staff?
Well, the physical interactions, Ola, are very limited. And the 3 courts have done a lot of work just trying to get people out of the courthouses, because as I described yesterday, they're petri dishes for the spread of contagion, because they attract so many people. For example, the Calgary Court Center in one day will see on the average 2,200 guests, people coming through. We've been able, over the last 3 weeks, essentially, at the last count that I obtained last week was that there were 200 people, as opposed to 2,200 in the courthouse on a given day last week. But that's still a lot. That's still too many. So I think that perhaps, you know, the best way to answer your question is that everyone who's working as staff is concerned about their health and about the health of the public. And so ways that we have devised to reduce people coming to the courts have been, for example, the use of a drop box now. And that was an initiative of RCAS, the Resolution and Court Administration Services, limiting the access of runners from law firms to a particular hour during the day, so that there was, you know, getting the business done and then leaving. And so, you know, there have been any number of ways to simply reduce that physical presence of people in the courthouse.
And I think that in your press conference yesterday, you indicated that your wish was to see that number reduced even further, to see less people coming into the courthouses.
Absolutely.
Yeah. Chief Justice, why don't you take us to some of the immediate changes that our lawyers are seeing now?
Well, I think I've spoken for quite long enough, and maybe we'll get a change of tone. And I'm going to invite Associate Chief Justice Nielsen to take over.
Well, Ola, as you've hinted, there have been a number of changes since about March 15th. Filing deadlines have been suspended until May 1st under the rules of court, except for those applicable to the commencement of proceedings, including originating applications, although since we gave our direction, there has, of course, been a ministerial order that was issued by the minister. Initially, until May 1st, we were only hearing emergency or urgent matters, which were defined in our pandemic response plan and in various documents that we have put up on the website and our announcements, which initially emergency matters were related to those in which serious consequences to persons or harmed property may arise, and then we had a list of them. We have relaxed that somewhat in the sense that we are now hearing more than we had initially thought we would be able to. So, for example, in the family area, we are looking at urgent orders relating to parenting time, contact, or communication with the child that cannot be reasonably delayed. In the commercial area, we are looking at and hearing urgent or time-sensitive matters where there are immediate and significant financial consequences, which may result if no hearing is heard. So we've expanded our emergency and urgent matters. We have relaxed things so that we're now hearing desk applications, consent orders are being submitted and are being processed, and we are now processing both at the masters and justices level various applications, including surrogate, desk divorces, etc. All scheduled matters, including contested applications and civil trials, have been adjourned from the period March 16th to May 1st. Criminal matters up to May 1st have been adjourned, and in particular, Queen's Bench appearance dates for further arraignment. Jury selections that were scheduled between March 13 and May 31st have all been postponed. As I said a moment ago, all signed consent orders may be submitted to the Queen's Bench or the Masters for execution and signing by us. We got lucky maybe in some ways in the sense that Rule 4.16 was amended very recently, sort of not because of the pandemic, but it is a bit of an added bonus to us because it allows us to perhaps, and we are going to be looking at the judicial dispute resolution area, but it gives us some more flexibility in directing matters to judicial dispute resolution and or alternate dispute resolution. So that, as I said, was a bit of a bonus. I guess other things that have happened, of course, is now the ability to email file documents with the court. Those with fax accounts are able to do that, which has certainly facilitated access in the sense of filing. And we worked with the Law Society in dealing with the remote execution of affidavits, which has, I think, facilitated the filing of documents and the hearing of urgent or emergent matters, because folks are able to undertake those new procedures for executing affidavits and get matters before us on an urgent and a very quick basis. So those are some of the changes. It's a moving target because we're changing things as we go to try and facilitate access to the court, but as Chief Justice Moore said, at the same time keeping everybody safe.
It's important to remind people, I think, all of us, that while the courts can change limitation periods, suspend limitation periods that you find in the rules, it's important to be mindful that legislative limitation periods, so limitation periods found in various statutes, of course, you don't have the jurisdiction to suspend those. So it's important for lawyers to keep in mind that they may have to look at the running of different limitation periods and be mindful of that.
Well, I think I've got to add to that, Ola, that you got to be careful in matters like Rule 4.33, the drop dead rule, which if you go to subsection 10, does not permit the courts to make changes to extend those periods that apply there, or to Rule 3.26, dealing with the renewal of statements of claim. So if relief is sought in those two areas, then one needs to look to the legislature to deal with those matters.
Right.
So there's some questions around those.
Yeah, and certainly what we've heard is there's some concern from particularly civil litigation lawyers who are unsure what to do in the meantime. Should they take a next step? Should they, for example, try to book questionings if that's the next step in a piece of litigation? They want to make sure that they do what they can without, in July or August, having to worry about the other side saying, well, you could have taken a step, you didn't take a step, and that ought to result in some prejudice in terms of what happens to your case. And so I understand, Chief Justice, that you're meeting with some of our civil litigation section executives and the Civil Trial Lawyers Association. That certainly is an issue that is top of mind.
Well, I guess what I might say in response to that is nothing we have done has in any way suspended what lawyers can be doing on their files. It just gives them some relief with respect to those deadlines that might be applicable under the rules of court that we might have some control.
Right. Let's talk a bit about the emergency urgent applications. And my understanding is that there's a online form on the Queen's Bench website itself where lawyers can designate a matter either as being urgent, an emergency, and then provide some reasons as to why they're seeking that designation. My question is, do you have a sense as to what the turnaround time is from someone having submitted that application to a decision being made and communicated back to the applicant?
Well, it's a very simplified process. We haven't basically encouraged everyone, if they have access to a computer, to complete the online form. We recognize, however, that not everyone has that access to a computer, so there is an ability to phone in. But those forms are completed and they go to one of two court coordinators, one in Calgary and one in Edmonton, and then they are sent out to what we're calling the triage judges, who look at them, and they are being processed on the same day that they're received, if it's early enough. If they come in later in the afternoon, which they can if they're online, it may not be until the next morning. But I spoke to the triage judge here in Edmonton this morning, and when he turned on his computer, he had 5 of them to look at. So they're being processed as quickly as they can be received.
Last week, for example, Ola, we had 88 of those forms over the course of the week in Edmonton. And they were in any number of areas. In fact, all subject areas that you mentioned earlier in terms of the bars that we are meeting, members of the bar, 62 of them were approved for hearing. And those are being triaged for immediate hearings. They're generally matters that can be resolved fairly quickly and with not a lot of materials. And it is the obligation of the triage judge to set them down. And we have a couple of other judges running our emergency justice chambers. So it took a little bit to get it organized, and it's working well. I think now people got the hang of it. Of course, their notion of what is urgent is a little more subjective than ours. And so there is a bit of a misunderstanding, perhaps, or a confusion as to what really is an urgent matter in our current context.
Can I maybe just do a public service announcement here, if I might, Ola, and that is this, that for the members of the bar, it is imperative that you they fill out the forms, because that's the best way to get before the triage judge for an assessment. We are really, really discouraging people from simply walking into our emergency chambers, because there may be some queue jumping that goes on when it may not be an emergent matter. And again, it is increasing the number of folks that are coming into the courthouse, which we're trying to minimize, obviously.
And if you're a lawyer who's made an application to have a matter considered either urgent or emergency, and that application is denied, and either they feel that they want to have a rehearing on that issue, or circumstances change such that they now feel that they can meet that criteria, what is the process? Is it resubmitting the form, or is that considered, is there some kind of an appeal process, adjudicative process as to how you deal with those?
There's no appeal, and there are no reasons. We don't have the luxury of time of giving reasons why something may not be emergent or urgent. It is pretty easy to determine from our list of matters that we have set out in our various announcements. Certainly, if there is a change in circumstances, that would always be a reason to come back.
And over time, Ola, our vision is to expand. So just for example, what we're working on right now is the schedule for the return of canceled JDRs over the last 3 weeks. The JDR is not necessarily urgent, right? But the JDR has the advantage of being a resolution technique that might mean that an eventual trial can be resolved and we don't have to book that trial. So it takes the logjam out. And the other advantage of it, of course, is that it does not have to be recorded on our, what we call the FTR system. The Queen's Bench is a court of record. And so most of what we do, let's put it this way, everything we do in the courtroom needs to be recorded. And that presents some challenges to us that we're busy trying to overcome. But you can have a video JDR hearing. We know that's going on in the bar right now with mediators dealing with matters through the WebEx system quite effectively. And so we want to join that group essentially and get back to the JDRs that were canceled. We have prioritized for Edmonton and Calgary and the regions, again, in those 4 hubs. Just as of today, looking at all the files that have been set aside, putting them into a schedule, having our judges conduct those JDRs from their homes, obviously. And we picked the ones that were canceled because we suspect that there's briefs already done on those. So the ones that were from March 16th to May 1, most of those have briefs ready to go and we could get to those right away. We would then look at offering JDRs for canceled trials, canceled civil and family trials, because we feel that if those matters were close to trial, probably these lawyers are in, not probably, for certain these lawyers would be very much on top of their preparation for trial. And we would offer them that kind of a 11th hour JDR to determine if they can resolve their case. So we're going to be triaging JDRs in that fashion. I think Ken can speak to you, or Ken Nielsen can speak to you a little more about other matters that we are triaging, for example, criminal pretrials. So I'll put it over to you.
We've just this week really are instituting a process to pursue criminal pretrials for all of the matters that were adjourned for the period starting in mid-March to the 1st of May. So all of those pretrials we will proceed with. We're going to do pretrials again on all of the trials that were canceled. And then we're going to go back and do follow-up pretrials on pretrials that may have been conducted from the 1st of February to the middle of March. We've set together a roster of judges both in Edmonton and Calgary to do those, and then the supervisors in the various centers will do pretrials. The idea is to see if we can hopefully promote some resolution of criminal matters through either guilty pleas and summary dispositions, through re-election from judge and jury to judge alone, or if nothing else, to simplify indictments to have matters proceed only on those charges that are fundamental to the indictment, and we're encouraging agreed statements of facts, reduction of witness lists, so that if we do have to take a matter to trial eventually, then it is perhaps in a more simplified form. But we have targeted those various areas for additional criminal pretrials in hopes again that we might facilitate getting those matters resolved quickly, and if not, at least getting on with the trials as quickly as possible.
You know, what both of you are speaking about is really what people are concerned about. I know it's top of your minds too, and that is that every day we're creating a backlog. And so that when we emerge post-COVID, that might be June or July or whenever that is, we've got this massive backlog, not only of things that have been adjourned, certainly all the hearing matters, but every day where we would normally have people come in and, for example, come into docket chambers or morning chambers, those matters are piling up. And so if we can spend a couple of minutes talking about how we can deal with that, and I know you're looking at certain triage options. The question that I get much of is where you have contested matters between lawyers, so you don't have self-represented parties. They're going on written submissions. There's no viva voce evidence, so no live witnesses. All the materials have been filed. What can we do to expand our capacity to deal with those via video conferencing only, or some other technological means which doesn't require parties to come into the courthouse? And it may mean that parties don't get to speak for 2 or 3 hours, but the argument is that submissions have been filed and judges can make decisions based on the materials in front of them. And I'm curious as to how you're weighing some of those options.
There certainly all are options, you know, but we've got to remember a very important option here, Ola, as this backlog, as you described it, accumulates, and that is that, you know, we're really encouraging the bar to look at their files, explore alternative dispute avenues, pick up the phone, look at whether or not their morning chambers matter that they've now lost. It really needs to be revived, or whether or not they can resolve the dispute and take the pressure off the courts while we're going through this period. From our end, we're looking at triaging matters. So for example, I would see us triaging family law matters, our heavy chambers and our special chambers. What we're considering right now is the ability to have an early intervention case conference before setting that special for an unknown date, really, or a date that's coming up for a purely for a hearing that would be by video. The other way of pursuing matters, of course, is, as you've mentioned, you know, you can do it in writing. You can make a submission on any special chambers matter in writing, and for that matter, there's room to do that in summary judgment applications and in summary trials where there is no viva voce evidence. So we can triage into hearings that are by video, provided we've got an FTR machine on in the courtroom, and that requires a clerk. We can triage to desk applications where the matter is relatively simple, and we're doing a lot of desk matters now. And by the way, they're not just the urgent ones. We'll take a simple application for our emergency duty judges, our roster judges to deal with. And then there's the in writing, a fully in writing application. But there we need the waiver from counsel to you know, dispense with the oral hearing. So we've got to go through a few things. On the civil side, I see that we'll be able to triage effectively. But I can't help but press this button over and over again that, you know, while we're busy getting in gear, and you folks are in your homes with a computer and a telephone, it'd be very useful for you to do as much work as you can before bringing the matters back to court. Obviously, in the criminal realm, and Ken Nielsen's spoken about criminal matters, and the backlog there is something that's going to be a great concern, and I mentioned that yesterday. But using devices like the criminal pretrial conference, really, which is about unashamedly, unabashedly, resolution, if there is an ability to resolve the matter or pare it down. Those are the instruments that we're hoping actually will not result in this tidal wave of matters on backlog in the various disciplines we're looking at. So as we speak, you know, we've got hearings going on, commercial hearings, we have the master's hearing matters that are urgent, and as we get more of them back in gear remotely, that is more masters, more justices to do the work. I'm hoping actually that tidal wave will dissipate. We'll kind of do a flat line as opposed to, you know, having this peak whenever that might hit after the state of emergency is terminated by the chief medical officer in the government.
Yeah, you know, what I'm hearing from both of you is that as capacities expands, as lawyers get a sense of the ground beneath them, we're going to be looking at Associate Chief Justice Nielsen. I think you talked about, you know, the way in which we characterize urgent and emergency applications. I think we can probably lower that threshold depending on where we are from a resource perspective. And Chief Justice Moreau, I'm hearing you saying generally, it really is as we move into April, we're looking at triaging and expanding as many hearings remotely or by video conferencing as possible.
We're doing a number of tests with, we're on Zoom today, we're using what's called WebEx. The beauty of it is that it ties into the current systems that we have at the courthouse, so that if we do a video recording that needs to be on the record, it ties ties right into our FTR reporting system.
Associate Chief Justice, I'm sorry, I can't hear you.
Okay, I'm sorry. I was just saying that we're on Zoom today, but we are using at the courthouse something called WebEx, which ties into our technology here at the courthouse, so that when we move to video conferencing, we will be able to record those matters that we need to be recorded. And we have had great success with the tests that we have done today. Provincial Court, in fact, conducted a 2-day trial probably 3 weeks ago that went very well on WebEx. So that is going to make the matters that we hear remotely much easier to do.
Associate Chief Justice, can I just get you to move a little closer to your microphone or to your computer? I had a hard time making that out.
How's that?
We'll speak up.
We'll holler.
We'll holler at.
Okay. Chief Justice Moreau, you talked about, I think, promoting and encouraging and engendering a culture amongst the bar where we're going to have lawyers come together and work together to get through this in terms of identifying matters that can proceed through the processes that we have. Does that also raise the corollary that there may be more ways of punishing, and I say that within quotation marks, it might be through costs, awards, or others, where we're trying to make a point, we're really forcing lawyers to make some pretty hard decisions about how they want to proceed on their files?
Well, I mean, those are questions I think that really are tied to individual circumstances. I think that there is some strengthening in the court saying this matter should really go to some ADR work by virtue of that amendment to Rule 4.16 that I think will really be helpful. And just fortuitously in the criminal area, we have amendments to the criminal code that came about in September of 2019, again, well before COVID-19, that provided specifically for video conferencing and audio conferencing with accused, and in fact, conducting the possibility of conducting a remote trial. So I'm not sure I want to talk about punishment at this stage, at this very sensitive stage. I would rather talk about rallying around the idea of working at creative solutions. Certainly that was the banner discussion in Jordan in the criminal area, was that the stakeholders in the justice system need to work together better to avoid delays in criminal processes. And I think that equally applies to the civil world. And, you know, I'm so aware of how we came into this pandemic situation with lead times in our court that really were very concerning. So we do have to take some very aggressive steps to deal with the current crisis, but also long-term, how we deal with justice and access to justice in an effective way. And all the indicators, Ola, and you and I have spoken at some length about family law matters in the past. The courtroom is not the best place for family law. Family law matters should be triaged as quickly as possible out of the court system, because we know that the adversarial approach does nothing to help families, and certainly that's the principle the Reforming Family Law Justice System group has promoted I think very effectively in this province. So why don't we really have a hard look at where we can triage matters before they get into the courthouse or as they come into the courthouse to alternative means of dispute resolution. That's going to get our trials down in the family law area and perhaps leave some room for other matters, trials that need to proceed, where the principles are different. And we, you know, of course, we're a court that needs to sit and do trials from time to time. But I'm not persuaded that we need to, to do them all. I think we can do our work very effectively up front.
Right. I'm mindful of time, and so, but before we leave this area, I just want to let everyone know that, Chief Justice, you emailed me a series of frequently asked questions with respect to matters in Queen's Bench, and I understand you're going to be posting those imminently. They cover a number of topics that we haven't had a chance to discuss today. And some of the questions are quite specific to various practice areas. So I would suggest to everyone who's on this call to get on the Queen's Bench website and take a look at that. There's some very good information in that. So thank you for sending those to us. Let's spend a couple of minutes and let's talk about transition. At some point, we'll receive, a decision will be made to lift the restrictions that arise from the public health emergency, and it's quote unquote business as usual. And so one of the concerns certainly is how do we do with the backlog of those matters that have been adjourned sine die from middle of March to certainly until May, and it may be until later than that. And the question really comes down to priority. Will they be set down in the same priority in which they were originally scheduled? Will it just be a first past the post in terms of whoever's able to come to the courthouse and set those matters down? Do you have a sense as to how we're going to look at setting those matters down again for hearing or for trial?
Well, firstly, it won't be the first that happens to get into the courthouse door, nor will it necessarily be the first one being heard is the first one that was adjourned on May 16 or March 16. We're going to be looking at all of those cases and determining which ones need to go before the others. Obviously, the criminal matters have to take some precedence here because of Jordan and frankly the difficulties we were in with Jordan before COVID hit. But all options are on the table and are being considered by us now to try and deal with getting things back up. It won't be business as normal. It'll be business as new normal given what we're going through in COVID. But it really will, and you keep hearing this word triage, but we're looking at everything to try and determine how best to deal with the backlog that we know that is inevitable, even with all of the cases that we're hoping will be resolved in the interim.
Yeah, Ken Nielsen's Pandemic Response Committee and members of the administration are actually actively working on a scheduling framework that really is triaging the work that we do into a schedule and how we're going to approach it. And we're moving along fairly well in it and hope to be able to, unveil it at some point soon. But yeah, that has been a real priority for us. But we can't simply say to you, we'll take the first trial that was canceled and make it the first one. We've got to really look at what is a priority. We've got in custody accused who've had their trials delayed and whose bail will perhaps not be reviewed successfully if application is made. We have those who have bail reviews and their bail review has been successful. That means their priority is a little less serious than the ones who are still in custody. So the triaging, I think, is a pretty complex process. The sooner we get back to work, though, and dealing with, for example, our special chambers lists, et cetera, perhaps through some ADR means, and the sooner then I think that we get rid of this backlog.
I received an interesting email from a lawyer who said to me, we've got a trial scheduled this summer, but it's not really a priority. And, Chief Justice, speaking about the culture that we want to engender, she said to me, there are matters that will have been adjourned that are more important than mine, and those may have to get priority. So it's interesting how you're balancing priorities between adjourned matters and then figuring out what that looks like in respective matters that have already been set down and finding a balance. And I suspect we'll be working our way through that together. Touching on technology, how are you thinking about extending whether it be certain technological innovations, reliance on video conferencing that you think has worked really well and you've seen some really good upside efficiency? Is there a thinking that those are steps that we may then extend beyond as a permanent or at least on a pilot project?
I think for sure, Ola. I think the way we do business at the courthouse, both as judges and as lawyers, has changed fundamentally because of the pandemic, and that we will be doing things much differently and much more in line with current technology. The email filing is an example, but e-filing is a much better example where we will move hopefully to a paperless system. And I think the pandemic has probably pushed us down that road much quicker than we would have been otherwise. But no, I think technology will change the way we do business, and certainly the court has always been interested in advancing its on the technology front. We have been limited by funds over the last several years, but as the Chief Justice said, the government has, and the Minister has been very, very supportive of moving forward on the technology front and moving very quickly.
Thank you. In looking ahead, and I don't want to spend too much time on this because we are in a state of flux, and what we know today might look quite different in half a month or even a month. Chief Justice, you were quoted yesterday as saying this: "The tragedy of the crisis has led to the urgency of putting into place some IT solutions which will be in place for the long haul and affect some really fundamental changes in how we do our work in the court." And that really talks to, Associate Chief Justice, what you just said. I'm curious as to how that's going to play in the court's strategic priorities moving forward. Of course, the Queen's Bench has strategic priorities, and I suspect, and I'm curious as to whether or not you're going to have to sit down at some point and look at what those are going to be and what the order of priority will be.
Well, coincidentally, we were in the middle of a strategic planning cycle when I got this job. And already IT innovation was very much on the plate. And we were making submissions to government to ensure that we get into the 21st century. That cycle actually now is almost finished, and we're into a new strategic planning cycle. And in pre-pandemic, when our executive board met, the first item of business was always IT. And so it isn't going to change. It has not changed as a priority for us. We recognize that once we can put into place IT technology, cloud storage technology to secure our data, our judicial data, our court data, these are very important steps that would then solidify the security of of the work that we do, but also create a lot of efficiency. So I think that you marry these IT changes with other interesting changes, and one of the other priorities we've identified for the next cycle is transformational roles of staff. And so our judicial staff can now look at taking on different roles because they are liberated to do so, free to do so, by the ability to do things technologically much more quickly. Some of the stuff we did we did because of budgetary issues, and these were moves towards remote hearings of chambers matters, master's chambers matters. It was not a good news piece for lawyers practicing in our regional centers, where they had previously had masters visiting those regional centers and doing master's chambers in person. And before the pandemic struck, we had created a system whereby those applications would be done by telephone. That's part of the reality of being a streamlined organization, in the sense that you've got to look at what you're prioritizing in terms of personal hearing. So obviously we've got to start on that. I want to reassure the bar that this is a court that is a circuiting court. We do our trials in terms of our criminal matters where the offense has occurred. And so while we are in this emergency period of time where we will be doing trials, and I hope that we do trials remotely so that we can get the backlog down, there still will remain that need to be out there in the community so that justice is seen to be done by the residents of a particular community. In the civil area, I think there's a lot more room for expansion of the remote trial and application.
You know, I've been cautioned about thinking only in terms of technology and technological innovation, and that really, you know, one of the things that is central is the rules and what rules govern how we can get hearings through and deal with claims and so on. And so, do you have a sense as to what the role of the rules of court committee is going to look like? I suspect that they're going to be engaged in some very focused thinking on whether or not we need to pair up whatever we do on the technology side with some pretty fundamental rules work.
Well, I think it's probably fair to say that the Rules of Court Committee is looking at those things on a regular basis, but I would expect, and I'm not on the Rules Committee, nor is the chief, but I would expect that what we've experienced through the last few weeks and probably in the next few weeks will result in them having a much closer look at those things, Ola, and seeing if there are fundamental changes in the rules that need to be made as to how we might be conducting matters in the future. That's a little bit out of the control of the court because it is a separate committee that, of course, has government representatives on it, etc. But I have no doubt that they'll be looking at it and looking at it fairly aggressively.
So how can we help? We have lawyers and members in any number of sections that have practical expertise. They are subject matter experts. How, from your perspective, can we deploy the CBA in this post-COVID world where we're looking at change and we're looking at reform? How can we be of most assistance?
Well, I think, Ola, you already are. This webinar is a way that we have to communicate to your members. You know, my only disappointment today is I'm far, and Ken Nielsen, we're far away from you, given some technological constraints. So you see that it's still a work in progress, and perhaps on our next meeting, we'll be right there at the table with you, obviously virtually, but closer up. But you really already lent support as we navigate these pretty rough waters. And with these meetings that we're going to have regularly with the different specialties within the bar, your members, I believe your leaders, are involved in each and every one of those meetings, and we rely on them to send messages to members of your different sections, north and south. For example, ideas for how to deal with a particular procedural issue that's causing delay. We got some really great feedback last week at the criminal meeting, but also particularly the family law bar got pretty active in making suggestions. So we're having meetings regularly, about every couple of weeks. So everybody gets to put their thinking cap on and come back with some fresh ideas. It's a pretty entrepreneurial time right now, and we very much appreciate I think the courtesy that we've had from the bar, the patience that we've had from your members. We're really getting mostly positive messages. It kind of assists us in navigating, as I said, these waters. So that kind of support in the future, don't underestimate its value because we're human. But also we do understand that we may be doing things in a way that's too complicated or not quick enough. And if you've got alternatives to suggest to us, we're open to them.
Thank you. And I think for any members on the call, all of you are going to have ideas and experiences, and you're going to want to communicate those ideas. And many of those ideas are outstanding. And I think the best way to get those to our court leadership is to communicate through our section executives. They will then hear from their members, and that's a way in which we can funnel all of those concerns and that experience in a way that is manageable, because of course the information that everyone hearing is overwhelming. Dear Chief Justice and Associate Chief Justice, I want to thank both of you. We talk about community and we talk about pulling together, And the work that I have seen from both of you in terms of meaningfully engaging with our members. And it's not about meeting with our members and saying this is what's happening. What I've heard is you are meeting with our members and you're saying, help us. Let's have a conversation. Let's explore ways in which we can move forward and improve. And it's that spirit of collaboration, of collegial working together. That's what really brings this community together. And I want to thank both of you. I also want to thank your staff. There are many people whose faces we never get to see and whose names we never know. They are not only your judicial staff, but the people that work in the courthouses. And I want to stop here for a moment because some of us have the privilege to be able to work from home, notwithstanding the challenges that gives rise to. But there are many, many people who don't have that capacity, and we send them off to work, and they're working in some very difficult and challenging times. I can well imagine clerks and counter staff dealing with people that understandably are stressed. And so I just want to spend a moment and thank all of these people. Please thank your court staff for us and on behalf of our association. We're deeply grateful for the work that they do. And so I think my parting words this afternoon is be kind to yourself, be kind to others. If there's a lawyer who you haven't seen in a while, or someone who maybe you've struggled with on a file and you'd rather not talk to, now's the time to reach out, because I think we all appreciate someone phoning us or sending us an email, just checking in, seeing how we're doing, asking if we need help. Chief Justice Moreau, Associate Chief Justice Nielsen, and also to Associate Chief Justice John Rook, who's on this webinar. I just want to thank you for everything that you do. And if there's anything that we can do to help, please let us know.